Jai Hind. On behalf of the Netaji Research Bureau, it is a great privilege and pleasure to welcome you all to the Sarat Bose Lecture 2026. Sarat Bose was truly a leader with a difference. He actually believed that one who is morally wrong cannot be politically right. He was born on the 6th of September, 1889, and he was schooled in patriotism during the Swadeshi movement of 1905. He belonged very much to that Swadeshi generation, and therefore believed in a version of Swadeshi internationalism, a patriotism that was not averse to learning from the best social and political experiments being conducted across the globe. He went to England to study, and he was called to the bar at Lincoln's Inn. There are beautiful letters that the 15-year-old Subhash Chandra Bose wrote to his Mejdada, Sarat Bose, in England during 1913. Sarat Chandra Bose plunged into the independence movement during the 1920s. As in the case of his younger brother Subhash, his political guru was Deshabandhu Chittaranjan Das. And they believed in the equality of Hindus and Muslims of Bengal. And on that basis, they wanted to craft unity in the freedom struggle. Many years later, when I was doing my doctoral research in Bangladesh, I would sit outside district record rooms at the end of the day, and people would come up to me and want to hear, of course, about Netaji Subhash Chandra Bose, who was a great hero for all of them. But there were two other leaders whom they genuinely respected, and they were Deshabandhu Chittaranjan Das and Sarat Chandra Bose. Sarat Chandra Bose spent 8 long years of his life in prison, in British prisons. First, from 1932 to 1935, he had joined the second phase of the civil disobedience movement. And of course, the British suspected him rightly of also providing succor to the revolutionaries of Bengal. And then the second spell in prison lasted from December 1941 to September 1945. This was just after he had succeeded in establishing the progressive coalition government in Bengal under Fazlul Haq. But the British also had found out that he was in communication with Subhash Chandra Bose through Japanese channels and wanted him as far away as possible from Bengal and sent him to distant South India. For the purposes of today's lecture, I think it is important to emphasize that Sarat Chandra Bose played a leading role in the legislative front of the freedom struggle. He led the Congress's campaign in 1937 and became the leader of the Congress opposition in the Bengal Legislative Assembly in 1937. He was well known as a great speaker, as a barrister. In fact, we know that he was a great debater even in his presidency college days. He was renowned for his cross-examination in the Calcutta High Court. But there was always a literary touch in the brilliant political speeches that he delivered. For example, when the Second World War broke out, he spoke in the Bengal Legislative Assembly, saying that he was not prepared to wait with bated breath and whispering humbleness in our own land. Swaraj is our birthright. And he gave a justification for the choices that he and his younger brother were going to make to try and take advantage of the international war crisis. Once he emerged from prison in 1945, he was elected to the Central Legislative Assembly in November of that year. And he became the leader of the Congress opposition in New Delhi. And what is also not known is that he was initially elected to the Constituent Assembly. And if you look at the list of members from Bengal who signed the register on the 9th of December of 1946, it is a roll of honor, 25 names. The first signatory was Sarat Chandra Bose, followed, interestingly enough, at number 2 by B.R. Ambedkar, who had been elected from the Jessore and Khulna constituency to the Constituent Assembly. Now, here was a man who had devoted his life to the freedom struggle from 1905 all the way to 1947. But in the year of independence, he broke with the Indian National Congress, of which he had been a lifelong member, on the question of partition. He tried his level best until the very last moment to at least preserve the unity of Bengal. And I just showed Justice Muralidhar a photograph of Sarat Bose with Mahatma Gandhi in Shodhpur in May of 1947, when they were trying to find a way to keep at least Bengal united. But even after independence, of course, he tried to build a socialist opposition, and he won a spectacular electoral victory in June of 1949, while he was away in Europe being treated for his heart ailment. But he took 80% of the vote in the South Calcutta by-election. And it is a great tragedy that 6 months or 7 or 8 months later, he passed away. Finally, I would just want to say, given what is happening in our neighborhood, that in January and February of 1950, Sarat Chandra Bose wrote some of the finest editorials of his life. He had been managing Forward and Liberty from the 1920s, but he had published a new paper of which he was the editor, The Nation. He published some eloquent editorials in this paper in January and February of 1950, at a time when there was a lot of religious strife in both Bengals, West and East. And he called for peace with honor. He called for sanity and sobriety. He insisted that in his entire political life, he had never made any distinction between Hindu and Muslim. And in the final editorial that he wrote half an hour before his death, he called for East Bengal to live and flourish as a separate state. This Netaji Bhavan was dedicated to the nation by Sarat Chandra Bose in 1946, something that he formalized on the 23rd of January 1947. And it was 10 years later that his son, Shishir Kumar Bose, established the Netaji Research Bureau. So what we do here is to try and realize the vision that Sarat Chandra Bose had for this house, in the year of India's independence. We are very honored to have with us Justice S. Muralidhar to deliver the Sarat Bose lecture today. For some reason, today I'm remembering the lecture that was given in the centenary year of Sarat Bose by Tony Benn, the British socialist and internationalist, right here in this spot. This is a tradition that goes back to the 1960s. Justice Muralidhar is an apt choice because he is one of those rare independent jurists that we can be proud of in India today. He is at the moment senior advocate in the Supreme Court. He has served as judge of the Delhi High Court. We remember his enlightened opinion on 377, that colonial law, and also for the opinions that he expressed in early 2020. He served as Chief Justice of the Orissa High Court, and now he has been given a very major responsibility by the United Nations. He is the chair of the 3-member commission on the occupied Palestinian territories, including East Jerusalem and Israel. And we wish him all Godspeed in the work that he is about to undertake with 2 other major international jurists. Justice Muralidhar has also recently edited a wonderful book titled Incomplete Justice, the Supreme Court at 75, which contains his own writing, but also the contributions of many of our legal luminaries. So please join me in welcoming and inviting Justice Muralidhar, a great lawyer, to deliver the lecture named in honor of a great barrister and a selfless freedom fighter, Sarat Chandra Bose. Jai Hind.
A very warm good evening to everyone here. I'm deeply thankful to the Netaji Research Bureau, Professor Sarat Bose, Professor Sumantra Bose, for inviting me here. It is indeed an honor to be asked to deliver the 2026 Sarat Chandra Bose lecture. Through childhood, I had heard of the heroism and valor of Netaji Subhash Chandra Bose. In January 2021, I was sworn in as the Chief Justice of the High Court of Orissa, which, as all of you know, is located in Cuttack, where Netaji was born, and where his father, Sri Janakinath Bose, had a flourishing law practice. The Ravenshaw Collegiate School, where Netaji had his early years of schooling, is just next to the High Court. Netaji's elder brother, Sri Sarat Chandra Bose, in whose memory this lecture series is being conducted, followed his father's footsteps as a successful barrister. He abandoned law practice to join the freedom movement. As was told to us just now, Sarat Chandra Bose was a staunch supporter of his younger sibling, who was destined for a major role in the struggle for India's independence. Much has been written and spoken about the close relationship of the 2 brothers, which must all be too familiar to this audience. It does need reiteration that Sarat Bose was himself an ardent freedom fighter who underwent 2 spells of imprisonment, first between 1932 and 1935, and then again between 1941 and 1945. He was, of course, active in politics. Professor Sarat Bose has just told us about that. Sarat Bose believed in and lived a secular life, was deeply committed to the cause of communal harmony, equality, and unity. He naturally was opposed to the idea of partition of the country on religious lines. In independent India, he continued to champion civil liberties, resisting authoritarianism and the inheritances of the post-colonial state. There is so much to be learned and imbibed from the life of the most eminent Sarat Bose. It is indeed a privilege to be asked to speak in the very place where he lived and where many of the ideas leading to the country's independence took shape. The background to the theme of today's talk requires to be delineated in order to place it in context. For a democracy governed by the rule of law, the institutional arrangements that would be considered to be essential are a responsible executive accountable to the people and to the Constitution, an effective and functional legislature truly representing the will of the people, and an independent judiciary that can protect and enforce the rights of people and check legislative and executive excesses. The Indian Constitution lays out the broad scheme of separation of powers among the three branches of state and its concomitant doctrine of checks and balances. It is indeed neither a perfect nor a rigid separation. It is not even intended to be. The modern state envisages mutual supervision, interdependence, and coordination among the branches, if they intend working in public interest. We also have what Professor Mark Tushnet terms as the fourth branch institutions. He is referring to the plethora of administrative and supranational bodies that defy the traditional three-way separation of functions. For instance, the Election Commission of India performs a variety of functions which could be termed as legislative, executive, and quasi-judicial. So do several regulatory bodies in the areas of electricity, telecom, and so on. But for the purposes of this lecture, it is sufficient to note that in the scheme of our Constitution, no organ is expected to be the repository of so much power so as to imperil the autonomy and independence of the other. The key word here is expected. In the working of the Indian Constitution for over 75 years, the inherent tensions between these organs of state have played out in a variety of ways. To understand the doctrine of checks and balances in the traditional sense, let us begin with the executive, whether at the center or in the states. The process of elections culminates in the formation of a government by a political dispensation that commands the majority on the floor of the legislature, the House of the People in the case of the central government, and the Legislative Assembly in the case of the states. The legislature thus collectively decides who can form the government. The executive is accountable to the legislature inasmuch as any legislative measure that is proposed by it has to get the approval of the latter in order to become law. Of course, the executive can, and it is known to do on occasion, frustrate the legislative mandate by not actually bringing into force or delay considerably the operation of a law that has been passed. For instance, in the Industrial Disputes Act, they amended the expression industry way back in 1978, and we are today in 2025, and that modified, amended definition is yet to be notified. Likewise, the amendments to Article 22, Sub-Article 4 of the Constitution, that reduced the period of detention to 2 months if it was not confirmed by an advisory board. That amendment was never notified. The Supreme Court was petitioned by A.K. Roy, and the court said we cannot issue a mandamus to the executive government to notify a particular provision of the law. The Mental Health Act of 1987 or the Legal Services Authorities Act of 1987, both were delayed by over 7 and 8 years before they actually became the law. The most recent example is the Labour Code. The Labour Code has been notified almost 4.5 years after it was first enacted and assented to by the President. By and large, all the major policy decisions that the executive may take and which requires enactment of laws have to be tested first on the floor of the legislature. For sanctioning all its measures of generating revenue and spending them, the government, whether at the center or in the states, has to get the nod of the legislature during what is termed as the budget session, We are in for one beginning on the 1st of February. The planned and unplanned expenditures of ministries and departments of government, with the justifications, have to be presented for approval to the legislature or its committees, including, for instance, the Public Accounts Committee. There is therefore legislative oversight of executive action. There was a slight variation of this during the UPA regime between 2004 and 2014. If you recall, we had what is called the National Advisory Council, which was an extra constitutional body headed by Mrs. Sonia Gandhi. All the bills that ultimately came to be passed in Parliament, including the Manrega, the Food Security Act, even the RTI Act, and the newer version of the Land Acquisition Act of 2013, they were all first vetted by the National Advisory Council, then sent to the Cabinet and then to the Parliament. Of course, that has been dismantled since 2014. So far, we've seen the legislative control of executive action. What about the judiciary? There is, of course, judicial oversight of executive action, even of what is considered to be purely in the executive domain. For instance, under Article 356, the President may, on the advice of the Governor, and of course on the advice of the Cabinet, decide to dissolve a legislative assembly and impose President's rule. Now this was held to be amenable to judicial review. And in the famous Bommai decision, they set out a whole protocol. Importantly, they said the President in no instance will immediately dissolve an assembly. His proclamation is to first be approved by Parliament, and only then he can proceed to dissolve a legislative assembly. This is not there in the written word in the Constitution, but this one decision in SR Bommai versus Union of India had the salutary effect of reducing the number of instances of imposition of President's rule. Post Bommai, which was delivered in 1993, every time an executive government has attempted at imposing President's rule, it has failed. Perhaps the most recent example is Manipur, and we'll have to see how long that survives. But it has had the salutary effect of placing a check on executive liberally using this power under 356 to dismiss government's rule by opposition parties. Even the President's powers of granting pardon and remissions, that too has been made amenable to judicial review. If one will recall the Mrs. Gandhi assassination case, so one of the two convicts whose guilt was confirmed by the Supreme Court was Kehar Singh. When Kehar Singh's mercy petition was turned down by the then President of India, I think it was Mr. Venkatraman, it was challenged in the Supreme Court because the order passed by the President said, after the Supreme Court has confirmed your guilt, what is left for the President to do? And then the Supreme Court had to remind the President that the domain of exercise of that executive power of pardon was independent of judicial power, and he had to revisit the mercy petition. Most recently, we've seen the drama play out over assent being given by the Governor or failed to be given by the Governor to bills presented to him by a legislative assembly, this time in Tamil Nadu. Over a period of 4 years, over a dozen legislative bills were simply not passed by the Governor, not done anything about. He neither said that I cannot pass them, he did not return them to the assembly, and he just kept quiet. So when the Tamil Nadu government approached the court, one of the questions that arose was, this is a purely executive function. Is it really amenable to judicial review? The court answered it in the affirmative, set down time limits. Of course, that became the subject matter of an advisory opinion at the hands of the Supreme Court at the instance of the central government. But the point remains that even this exercise of an executive action of giving an assent to a bill of a legislative assembly is amenable to judicial review. We next move to the legislature. It is the government of the day that advises the President as a titular head of the Parliament and governor in the case of the Legislative Assembly to prorogue or convene the House, to determine the dates and hours of sitting, even to accept the resignation of a government prematurely, to call for elections and so on. Further, the purse strings, in a literal sense, are held by the executive, whether it's the salaries or perks of the staff and officers of the legislature, or the salaries and perks of the legislators, all of them come from the funds provided by the executive. The Union Legislature is bicameral. We have the Council of States, the upper house, and the House of the People, the Lok Sabha. The state legislature may or may not be bicameral. Many states do have legislative councils, but some don't. While in Parliament, a bill has normally to be approved by both the houses in order to be enacted into law, the Speaker of the Lok Sabha may simply accept the executive decision to characterize a particular bill as a money bill and thus completely bypass the Rajya Sabha. And this is what happened with the bill concerning the Unique Identity Authority of India, the UIDAI, which one fine moment, Mr. Arun Jaitley advised the government that let's characterize this as a money bill. We don't have to take it to the Rajya Sabha, which was suggesting a series of amendments to that bill, and they simply passed it by a voice vote in the Lok Sabha. When that was challenged in the Supreme Court, a fairly strong dissent was written, saying that the very validity of this act is in question. And the dissent actually strikes down that act on that basis. The point remains that whether the Speaker's decision to characterize a bill as a money bill is, of course, now pending before a bench of 7 judges of the Supreme Court. It can well happen some years down the line that a 7-judge bench of the Supreme Court may say, yes, Mr. Jaitley was wrong, and this UIDAI bill could not have been characterized as a money bill, by which time I think all of us would have had maybe 2 or 3 Aadhaar cards each. After the introduction of the Member of Parliament Local Area Development Scheme for Members of Parliament, and I think you have similar schemes for members of the legislative assemblies, certain amount is placed at the disposal of the MPs and MLAs for expending in their constituencies. And the finances for all these schemes have to be provided by the executive of the center or in the states. Then we have another aspect, namely the 10th schedule to the Constitution, and I'll be speaking about it at some length. By virtue of the 10th schedule, legislators belonging to a political party cannot step out of the line, cannot, for instance, express their opinion either in the Legislative Assembly or in Parliament, which goes against the advice of the whip of that political party. So by virtue of this, the legislature is virtually dysfunctional as far as the members of the ruling party are concerned. They are only sitting there to completely accept and agree with all the legislative proposals brought forth by the ruling party. They cannot speak against or ask for accountability of their own government. So there is therefore a very pervasive control over the legislature by the executive. Now we look at the judicial control over the legislature. That's, of course, the whole theme of today's topic, and of course the legislative control of the judiciary. I'll come to that in a minute. Article 13 of the Constitution enshrines the power of judicial review over legislative action. Not only the particular provisions of an enacted statute, but even an entire statute can be said to be unconstitutional by the High Courts or by the Supreme Court. This could be on the grounds of legislative incompetence, violation of fundamental rights, or violation of any of the mandatory procedures delineated in the Constitution. Some of the bills required ratification by 2/3 of the state assemblies, for instance. And if that is not done, the bill can fall by the wayside. Even amendments to the Constitution can be struck down by the High Courts and the Supreme Court as being unconstitutional. The same holds good for subordinate legislation as well. The courts also have a say on the happenings within the legislature, including what can constitute legislative privilege. The actions of individual speakers of the houses of legislature, whether in parliament or the state legislative assemblies, to punish for contempt or to disqualify, suspend, or expel a member of the legislature are all amenable to judicial review. Election disputes that are adjudicated by the constitutional courts, usually in the first instance by the High Court, result in disqualification of an elected member of the legislature. The courts have also mandated disclosure by all candidates contesting an election to disclose an affidavit, their criminal antecedents as well as the assets. This they did in the Association for Democratic Reforms case. And when Parliament tried to make a law to dilute this requirement, that law was again challenged in the Supreme Court and struck down. So today this requirement that we have, the candidates will disclose an affidavit, their criminal antecedents and wealth, arises directly from the judgment of the Supreme Court of India. After the 10th schedule was introduced, the power of the Speaker to decide disqualification applications is also subject to judicial review. When they inserted a clause in the 10th schedule saying the Speaker's decision will be final and no court will examine its validity, that clause was struck down by the Supreme Court. The courts are also known to legislate. In fact, they've met with a lot of criticism for this. They can lay down binding guidelines till such time the legislature enacts a law in the subject. For instance, we had a judgment in Vishaka versus Union of India, where in regard to sexual harassment of working women, the Supreme Court laid a series of guidelines after looking at the CEDAW convention and said that these guidelines will hold the field till such time Parliament makes law. It took a decade for Parliament to make that law. The court can also suggest amendments to a law. For instance, when the National Company Law Tribunal Act was being debated in the Supreme Court, the court suggested to the government that it could make a series of changes to the law. And actually, the government made those changes. Parliament enacted that, and that was again brought to the court for its approval. The courts can even alter the scheme of a statute when it comes to appeals to the Supreme Court. We have an Administrative Tribunals Act where we have a central administrative tribunal to decide disputes concerning terms and conditions of employment of government servants. The decisions of those tribunals can be appealed directly to the Supreme Court. But when the Supreme Court in Chandra Kumar's case examined the validity of that statute, it said it's not possible for all these appeals to directly land up here in the Supreme Court. It will just flood our case docket. So let us provide an intermediate tier of judicial review. And they mandated that all decisions of the Central Administrative Tribunal would be tested before a division bench of the High Court. So there is a great control of legislative action by the judiciary. Lastly, now we come to the judiciary itself and how it is amenable to controls by both the legislature and the executive. When we look at legislative control over the judiciary, a direct instance is the removal by way of impeachment of constitutional court judges. The motion for removal, signed by the requisite number of parliamentarians, is presented to the Speaker of the Lok Sabha or the Chairman of the Rajya Sabha, who then constitutes a committee to inquire into the charges. If any of you have been following the Yashwant Verma case, Justice Yashwant Verma case, you will know that such a committee has actually been constituted and is presently examining the charges against him. The report of the committee is then tabled in the House to be discussed, debated, and voted upon. We've had instances like Justice V. Ramaswamy case, where this entire process can be frustrated if the ruling party advises by a whip that all its members in Parliament should abstain from the voting. That is precisely what happened in the Justice Ramaswamy case. The Indian National Congress, through a whip, compelled all its MPs to abstain, and therefore the voting just collapsed. And Justice Ramaswamy survived and retired peacefully, had even a street named after him in Chennai. Even in this, the Parliament can be selective. There were two motions submitted to the Speaker of the Lok Sabha, one concerning a judge of the Allahabad High Court who continues to sit as a judge there, who delivered a speech in the precincts of the High Court at an event organized by the Vishwa Hindu Parishad, where he made some hateful comments about members of a particular community. And this was objected to seriously, and that formed the ground for seeking his impeachment. At the same time, another motion was presented to the Speaker for the impeachment of Justice Yashwant Verma. The Speaker took up the Justice Yashwant Verma motion first. Nothing is heard of what he has done to the motion to impeach the other judge. So Parliament can also be selective in how it deals with requests for impeachment. Another significant aspect of control by the legislature is the impact that the laws enacted by it have on the functioning of the judiciary. This is not spoken of very often, and I think we should pay careful attention to this. While the financial outlay needed for enforcing a law is usually tabled in the House along with the bill, you will have a single sheet at the end of a bill as parliamentarian Dr. Sugata Bose will be aware of it, which will tell us what is the financial outlay if the law were to be enacted or enforced. There is no such statement as to what the impact such a law will have on the functioning of the judiciary. Some years, 3 decades ago, they amended the Negotiable Instruments Act to make check bouncing an offense. That one change to that law resulted in lakhs of cases being filed in our magistrates' court. In Delhi alone today, we have over 10 lakh cases under the Negotiable Instruments Act. And all over the country, we would have over 10 million cases just under the Negotiable Instruments Act. So this one amendment can have such an adverse impact on the functioning of the judiciary. For instance, we have criminal law statutes. We have the PMLA, we have the UAPA, the Unlawful Activities Prevention Act, or the Prevention of Money Laundering Act, which make it impossible for bail to be obtained. What happens as a result is the pendency of bail applications, whether in the district courts or in the high courts or even in the Supreme Court, increases exponentially. So this is what is meant by judicial impact assessment. So the legislature is not mindful of this aspect when it enacts laws. The legislature can, of course, reenact a law that has been struck down by the judiciary after removing the defects pointed out by the court. The legislature can even seek to insulate certain laws from judicial review on the ground of violation of fundamental rights by placing them in the 9th schedule to the Constitution. The Parliament can also seek to amend provisions of the Constitution and the statutes concerning the appointment process of constitutional courts, judges, their terms and conditions of service, their removal, and of course, their age of retirement. In other words, Parliament can, by its actions, affect the independence and accountability of the judiciary. To give you a small example, increasing the strength of the Supreme Court from 30 to 34, that was done by a law made by Parliament. So Parliament controls how many judges can sit in the Supreme Court, in one sense. So far, we've seen Parliament control over the functions of the judiciary. Now to executive control. In 1993, through an innovative interpretation of the word consultation in Article 124 to mean concurrence, the judiciary sought to wrest the primacy in the process of appointment of judges to constitutional courts from the executive to the Chief Justice of India. The Chief Justice of India, of course, had to function in a collegium, which included 2 of his senior-most judges in the case of appointments to the high courts, and 4 of his colleagues in the case of appointments to the Supreme Court, transfers of high court judges, and so on. The attempt by the executive in 2015 to institutionalize the appointment process by creating a National Judicial Appointments Commission, NJAC, somehow did not succeed. The law was challenged in the Supreme Court and struck down by it. Despite the striking down of that law, what we have seen in the last decade is that there have been numerous instances of executive interference in the process, not only of appointment of high court judges and chief justices and their transfers, but even appointments of judges to the Supreme Court of India. We turn to an important aspect. The finances of the entire judiciary, including the salaries and perks of the judicial officers and staff, is from the funds provided by the executive in the states. Sanctioning of the posts of judicial officers and staff, notifying their appointments, financial and technical support for judicial infrastructure, provision of security for the courts, execution of summons and warrants issued by the courts, getting the police and administrative machinery to provide wholesome support to the functioning of the state judiciary. All of this is in the hands of the state executive. Without this, the state judiciary might collapse. We have a provision in the Constitution, Article 50, which talks of separation of the executive from the judiciary. And it is absolutely essential. In our northeastern states, it took almost 4 decades for this actual separation of the executive and the judiciary to happen. One is reminded of the tensions between the executive and judiciary playing out from the 18th century itself. In the pre-independence era, in the Supreme Court of Bombay, this is pre-1861, when Sir John Preter Grant found that the habeas corpus writs issued by the High Court, by the Supreme Court, were not being implemented by the then governor of Bombay, he got miffed, locked up the Supreme Court of Bombay, took a ship and sailed to England, and said, I will petition the Privy Council. In the post-independence era, we've had instances of tensions between the executive and the judiciary play out. The district judiciary is quite vulnerable. We had an instance in Nadiad in Gujarat where a magistrate was actually handcuffed and paraded by the police. And this attracted the contempt action and adverse comment of the Supreme Court of India. You have various instances of members of tribunals not being appointed at all, whether it's the consumer tribunals or other tribunals functioning in the country. Very often the posts of chairpersons, vice chairpersons, judicial members, technical members are not appointed for sometimes years on end. So this can frustrate the dispensation of justice. The various scenarios I have presented concerning checks and balances, because we've seen how the executive is amenable to legislative judicial control. We've seen how the legislature is amenable to judicial and executive control. We've seen how the judiciary is amenable to executive and legislative control. These scenarios concerning checks and balances are premised on a certain ideal set of conditions where the three organs have a healthy regard for each other, being fully conscious of the unwritten and grey lines that separate the respective domains. However, when there is a populist government in place which commands a sizable majority in the legislature, these checks and balances get skewed. Not just here, but the world over, there has been a backsliding of democracy and a palpable weakening of the institutions of democracy. The Human Development Report of 2023 noted how through the process of periodic elections in many a democratic country, in which the person first past the post is declared a winner, an autocratic government comes to power with a mere 30% majority of the polled votes in a multipolar contest. These dispensations are termed as electoral autocracies, brought to power through a so-called popular mandate in a pattern which has been oft repeated through history. Once these dispensations come to power through legal means, they proceed to systematically eviscerate the institutions of accountability of their power and autonomy. Populism trumps constitutionalism, pun intended. Now we come to the meat of the lecture, the stories that I'm going to narrate. So the theme of today's topic, and I've deliberately chosen certain appellations saying Speaker Saheb and My Lord for a deliberate purpose. It is to broadly represent the legislature and the judiciary and the tensions that have played out between them over the years. The first instance what I call is institutional posturing. In the first 2 decades of our republic, let's say between 1950 and 1970, there was a strong executive with an overwhelming majority, at least till 1967. And the early years saw Parliament immediately react to every move made by the judiciary, whether it was in the area of freedom of speech or land reforms. You had a series of constitutional amendments to overcome the effect of the judgments of the Supreme Court. One major change occurred in 1967 at the Union Parliament. But before I come to that, our focus shifts to March 1964, where the first major confrontation between legislature and executive and the judiciary took place, not in Delhi, but in Lucknow. This is the Uttar Pradesh Vidhan Sabha. One of the members of that legislative assembly was accused of being corrupt, and a pamphlet was published by one Keshav Singh along with 3 others and distributed in the legislative assembly. The assembly took adverse notice of it. So at the instance of one of its members, a resolution was passed. They held Keshav Singh in contempt of that legislative assembly. And on 11th March 1964, they decided that they will administer a reprimand. So in order to receive the reprimand, summons were issued to Keshav Singh. Keshav Singh lives in Gorakhpur. And he kept telling the speaker, listen, I have no money for the railway journey. I cannot come to the Legislative Assembly. So the Marshal of the Legislative Assembly was entrusted with the task of arresting Keshav Singh in Gorakhpur on 13th March and producing him in the bar of the Legislative Assembly on 14th March. What happened on 14th March was quite dramatic. Keshav Singh comes into the Legislative Assembly but refuses to answer any question. The speaker asks him, what is your name, sir? He says, silence. And worse still, he stands with his back to the speaker. He won't even face the speaker. The speaker nevertheless administers the reprimand. And then the speaker tells the Legislative Assembly, this Keshav Singh wrote me a letter on 11th March, 3 days earlier, where he maintained all that he had sent in the pamphlet. And he also added that when a legislator is corrupt, he is of course corrupt, and I will say it. At which point the Legislative Assembly decided to again punish Keshav Singh for contempt. This time they sentenced him to 7 days imprisonment. Why? One, because of the language used by him in his letter. He called the warrant issued by the speaker as a Nadir Shahi Farman. And he maintained his posture of not showing his rear side to the speaker. So they said for this objectionable behavior, 7 days imprisonment. So he was taken off to the Lucknow district jail, imprisoned there. 5 days after this happened, on 19th March 1964, one Solomon, an advocate, petitions the Lucknow bench of the Allahabad High Court, saying that this detention of Keshav Singh is illegal and mala fide, violative of his fundamental rights. That writ petition is accepted by a bench of 2. So they said we'll list it at 2 o'clock in the afternoon. At 2 o'clock in the afternoon, the government lawyer appears and he says, I need to take instructions. Pretty much the same thing that happens even these days. The court says we'll take it up at 3 o'clock. At 3 o'clock, there is no one representing the government. The court then quickly passes an order saying, release Keshav Singh on bail. So Keshav Singh comes out on bail on that very date, which is 19th March. Now, the government advocate is taking his own time getting instructions. He's told that, too late, sir, already bail has been granted. So he tells the speaker, can't help it, bail has been granted. What happens on 21st March is astonishing. The entire UP Legislative Assembly passes a fresh resolution. It says not only Keshav Singh, but his lawyer Solomon, and these 2 judges, one N.U. Beg and one D.S. Saheb, are all guilty of contempt. It's asked a warrant to be issued for them to be produced in custody before the Legislative Assembly. A shocking development. But the poor 2 judges had no inkling this was happening. On 23rd, one of the judges listens to this on the radio. He panics. And they're sitting in Lucknow. So this judge, Justice Sehgal, rushes to Allahabad from Lucknow. And there he petitions the court saying, what has happened? 28 judges of the Allahabad High Court, that is the full court, sit and they say this is a remarkable development, we have to stay this. They stay it. But the Legislative Assembly is not going to keep quiet. So on 25th March, Solomon hears that Sehgal has gone, Justice Sehgal has gone and got a stay. So Solomon decides, I'll also file a petition. Justice Beg also files a petition. Again, 28 judges sit on 25th March and again grant a stay of all their arrests. On the same day, the Legislative Assembly convenes and now says, I think our resolution was mistakenly interpreted. We didn't mean to punish them for contempt. We meant to give them an opportunity to come before us to explain their conduct. So things had already got out of hand. So on 26th March, the President of India makes a reference to the Supreme Court for its advice on whether by entertaining a petition challenging the decision of a speaker, punishing somebody for contempt of the House, did the 2 judges of the High Court commit contempt of the Assembly? Did the lawyer, by approaching the High Court, commit contempt? And could the speaker have implemented the resolution of the Legislative Assembly by requiring them to appear before the Legislative Assembly? So these were heightened tensions. Cut a long story short, the Supreme Court interpreted Article 194, Sub-Article 3 of the Constitution, which talks of immunity granted to the legislators and to the legislature for anything done within the precincts of the legislature. They said you cannot do anything that violates fundamental rights of individuals, and you have to follow some basic procedure. They said approaching a court for justice is part of the fundamental rights under Article 21. That can't be curtailed by you. So all those questions posed to the Supreme Court were answered to uphold the dignity of the high courts, the right of access to justice, and in a sense to say not all the privileges and powers that were enjoyed by the House of Commons are available to Indian state legislatures. It does get whittled down because there is a fundamental rights chapter, and this article, power under Article 194.3, has to respect the fundamental rights chapter. This is the long and short of what the Supreme Court had to say. But the postscript is very interesting. The Legislative Assembly passes another resolution, this time expressing its displeasure, not accepting the advisory opinion, and saying we express our displeasure and close the matter. Now, Mr. Sirvai, all of you have heard of Mr. Sirvai. He is a legal jurist who for many, many years was the Advocate General of Maharashtra. And in this particular case, he defended the UP Vidhan Sabha. He says in his commentaries on the Constitution, the 4th edition, that there is a true story to the Keshav Singh case. He says even before the case was taken up for hearing, he proposed to the Speaker of the Legislative Assembly that if the lawyer for the High Court is able to tell the Supreme Court that these two judges were not informed that their powers are limited and they could not have granted bail in a matter of punishing for contempt of the House, then maybe I will then get up as representing the Speaker to say, if the Legislative Assembly knew that the judges were not aware of this, the Legislative Assembly would also not have gone ahead. Setalvad was representing the High Court, turned to Sirvai and said, let the judges decide. So Sirvai was obviously miffed. I think Setalvad had already a drift of what was going to happen in the Supreme Court. But the postscript is really interesting. Keshav Singh's petition was again, which was pending. The writ petition, the same writ petition which was filed on 19th March was pending. It was taken up by a single judge of the Allahabad High Court, and every one of his grounds were rejected. The petition was dismissed, and Keshav Singh was told, you still have 1 day of imprisonment to serve, you better go back to jail. In the Union Parliament, something interesting was happening. 1967 was a watershed moment. The general elections of that year saw the Congress perform very badly. You will recall that that was the time of the split of the Congress. You had the INC requisitionists, headed by Mrs. Gandhi, and the INC organizational, which was Nijalengappa, Kamaraj and the others. Somehow she clung on to power with a motley group of political parties. So at the center, it was already weak. On top of it, she tried to bypass the parliament in trying to nationalize banks. She tried to bypass the parliament in matter of abolition of privy purses, all by executive orders. The Supreme Court had no hesitation in striking down these measures. But most importantly, when it came to land reforms in Punjab, there was an important decision in Golaknath versus State of Punjab, where the Supreme Court, by a majority of 6-5, very thin majority, said Parliament, power of amendment of the Parliament will not include omission of the Fundamental Rights chapter. In effect, it was telling Parliament, you may have the power to amend the Constitution, but you cannot touch the fundamental rights. Now, this was completely different from what larger benches of the Supreme Court of lesser strength had said in the previous decades. Mrs. Gandhi was naturally upset by this. Somewhere they were ceding the power of the Parliament. One of the biggest legislative powers of the Parliament is the ability to amend the Constitution. And said, how can an unelected judiciary just, curtail our power to amend the Constitution? So they waited, literally, they waited for that moment when they could find an opportunity to get this Golaknath decision overruled. That opportunity presented itself to her in 1971. Students of history will know that in 1971, the Congress, led by Mrs. Gandhi, came back with a thumping majority. One of the first tasks that the new government undertook, with the help of Mr. Mohan Kumar Mangalam, was to pack the judiciary. So they systematically started appointing, and that was the time when primacy of the appointments was still with the executive, not with the judiciary. So they systematically filled up vacancies in the Supreme Court of persons who they felt will agree with the ruling establishment. As it so turned out, when the Keshavananda Bharati case, with a judge strength of 13 judges, was set up, the main purpose was to see whether the Golaknath case was correctly decided or not. It is written by commentators that that case again was decided by a very narrow majority of 7:6. And what did they decide? They decided Parliament, of course, has unlimited power to amend the Constitution, including taking away fundamental rights, but, and it's a very significant but, is that Parliament cannot in any manner abrogate, abolish, or tinker with the basic structure of the Constitution. So this was a new doctrine introduced by the Supreme Court by a majority of 7:6, and this was something that Mrs. Gandhi could not have anticipated at all. What was the result of this ruling was that certain basic features like federalism, secularism, the freedoms under Article 19, judicial independence were all out of bounds as far as Parliament's power to amend the Constitution was concerned. So this, in effect, meant that the Parliament's power to amend the Constitution actually got even more weakened. So what started out as attempting to overrule the Golaknath ended for the Parliament in weakening its position. And this paradox sank in quite late. This was the time when Mrs. Gandhi was at the peak of her powers. We are talking of 1973. 14th April 1973 is that important date, because that's the date on which, 24th April 1973 was the date on which the Keshavananda Bharati case was decided. And there were attempts made subsequently by the Supreme Court, headed by Justice Ray, who superseded his three colleagues who were part of the majority in Keshavananda Bharati, to have the Keshavananda Bharati case reviewed. He set up a 15-member bench to have this reviewed, but that didn't succeed. What is important, therefore, to note is that this is such a watershed moment that despite a strong executive supported by a huge majority in Parliament, the Supreme Court had the gumption to tell the Parliament, listen, we are going to tell you how far you can use your power to amend the Constitution. There was another very important development regarding the tension between the Parliament and the judiciary around this time. All of us are aware that in June 1975, we had the decision of the Allahabad High Court invalidating Mrs. Gandhi's election to the Lok Sabha from the Raebareli constituency. A stay was granted of that order, conditional, by Justice Krishnaya sitting in the vacation bench of the Supreme Court on 25th June 1975. He basically said Mrs. Gandhi will not exercise her powers as a member of Parliament. Namely, she can't vote in Parliament. She can't participate in the debates in Parliament, but she will continue as Prime Minister of the country. The very next day, emergency was imposed, and the rest, they say, is history. But what is interesting is that election appeal of Mrs. Gandhi was listed for hearing on 11th August 1975. One day before that appeal was to be taken up for hearing, with the entire opposition in jails, all the leaders of the opposition, all the members of Parliament of the opposition were all in jail in the emergency. The Parliament convened a session and passed the 39th Amendment in the absence of the opposition. By the 39th Amendment, it was Article 329 capital A was introduced. And it was said that elections to the offices of the President, the Vice President, the Prime Minister, and the Speaker of the Lok Sabha will not be inquired into by any court, including the High Court and the Supreme Court. It added spice to this by saying, even if a judgment of High Court had invalidated any of these offices earlier, that will not hold good. Now, this 39th Amendment was challenged before the Supreme Court. Along with the 39th Amendment, they also made amendments to the Representation of People Act. Mrs. Gandhi's election had been invalidated on 3 or 4 grounds. Every one of those grounds were nullified by these amendments to the Representation of the People Act. So, very significant that on 11th November 1975, a judgment was pronounced in what I would term as Mrs. Gandhi's election case. It goes by the name of Indira Nehru Gandhi versus Rajnarayan. 5 judges of the Supreme Court were very clear. They said the 39th Amendment cannot survive. They struck down this entire Article 329A. Why? They said judicial independence and power of judicial review is part of the basic structure. You cannot, as a parliament, nullify judgments of the court. You cannot, by this amendment to the Constitution, take away the powers of judicial review. So they were very clear that the 39th Amendment had to go. But the irony is, and this bench included the great Justice H.R. Khanna. This was earlier to the Edim Jabalpur case. The irony was they upheld all those amendments to the Representation of People Act, as a result of which Mrs. Gandhi's election was validated. And Justice Jagmohan Lal Sinha's judgment was reversed. In my book, I've talked about the what-if moments. Legal scholars will know that this is called counterfactual. There's a whole study of counterfactuals. I was asking in that book, what if Mrs. Gandhi's invalidation of Mrs. Gandhi's election had not been stayed? What if Justice Krishna had not granted a conditional stay at all? Would they not have been forced to seek another leader to substitute her? And would that leader in a weakened parliament have had the gumption to declare an emergency? We don't know. We don't know what could have happened. But just shows us that the tensions between the parliament and the judiciary were at a height during that period. And here I would say, by invalidating the 39th Amendment, by reiterating the basic structure in the Keshavananda case, the judiciary came out in brighter colors. Very soon that was to get dismantled. We had the Edim Jabalpur case, which upheld the abrogation of the right to approach courts under Article 226 of the Constitution, under the draconian Misa law. All that is history. So we've had this posturing in 2 aspects. One, state legislature, Keshav Singh, the tension between the judiciary and the legislature. And here, in matters of amendment to the Constitution, the court telling the legislature what it can and cannot do. There are a few other contexts of the tension between the 2 institutions, which I will now refer to. The first is what happens within the precincts of Parliament, the powers of the Speaker to expel members of Parliament. A sting operation was carried out in the early 2000s. In the sting operation, a private TV channel was able to show that 10 members of Parliament were very happily accepting bribes to ask questions in Parliament. One of those members was a member of the Rajya Sabha, was even asking for a cut from an NGO for spending the Member of Parliament Local Area Development Scheme funds. Those videos were played before the Privileges Committee of Parliament. Those MPs constituting the Privileges Committee had no doubt that this was sufficient proof. They held all of them guilty of contempt, expelled all of them. Promptly they ran to the Supreme Court. So one of the grounds that was urged is the Speaker can suspend a Member of Parliament but cannot expel him, because there are limited grounds in Article 102 and 173 of the Constitution to disqualify a member either of the Parliament or the Legislative Assembly. This expulsion will amount to disqualification. You have no power as a Speaker or as a Parliament to expel members. The Supreme Court this time agreed with the Parliament. They said those disqualification provisions are there, but you have power to ensure dignity of the House. You can say that the acts committed by you have lowered the dignity of the House, and you can therefore punish for contempt. As part of that power to punish for contempt, you can even go so far as to expel someone from the House. Now, the irony of this is, you expel a Member of Parliament, the seat falls vacant, that same Member of Parliament can contest for that seat. So even in the sting operation, Raja Rampal is the name of the case, at least 4 or 5 of those MPs who were expelled from Parliament again contested, and again, to the best of my memory, served 2 or 3 terms in the Lok Sabha thereafter. So there is always an ironical twist to many of these tales. Then we have the instance of a legislative assembly trying to use its contempt power to expel one of its members, in this case Captain Amarinder Singh. The 13th Punjab Vidhan Sabha, one of the first things it took up for consideration was the misdeeds of Captain Amarinder Singh, who had been ousted from power while he was Chief Minister during the earlier term of the Vidhan Sabha. They said, oh, you've granted unfair exemptions from land acquisition to some entity. This is corruption. This is therefore an insult of the House, and therefore we are throwing you out of the House. And for the rest of the term, the Supreme Court said, no, nothing doing. We're not going to permit this. This was an executive act committed during the earlier term of the Vidhan Sabha. It had no nexus with his functions within the House as a member of the Legislative Assembly. So we are not going to permit you to expel a member like this. So you had the Supreme Court come every now and then to test out two things. What are the extent of the privileges and powers of Parliament? They have evolved what is called a functional test and a necessity test. Are these functions that you seek to exercise absolutely necessary for you to function as a member of the Legislative Assembly or a member of the Parliament? Not any and every such action can be justified by you. For instance, bribe givers and bribe takers. This is a very interesting story. 1991, Narasimha Rao is heading a weak majority, not even a majority, it's a minority of Congress MPs. They want to form the government. This was the time when Congress was supposed to lose the election, but Mr. Rajiv Gandhi's assassination in the second phase completely changed the mood of the nation, and therefore Congress became the party with the largest number of seats. It needed help of other parties. In now what is acknowledged as the suitcase episode, large amounts of bribes were given to members of parliament belonging to the JMM. They promptly voted in favor of the motion of confidence in the Congress, and the government survived. Cases were filed against both the bribe givers, which is Narasimha Rao and some of the other MPs, and the bribe takers. One of the bribe takers was Ajit Singh. He was heading the Indian National Lok Dal Ajit Singh faction. Some of his colleague MPs, accepting the bribe, voted in favor of the Narasimha Rao government. Ajit Singh decided to abstain. The question before the Supreme Court was this. All of these MPs argued that this all pertains to what we are doing in the parliament. For anything said or done in parliament, there is an immunity. No court can look into it. So who are you to prosecute us? No court can attempt to charge sheet us, frame charges. The Supreme Court was split in what is now confidently stated to be an absurd judgment by a majority of 3-2. They said anyone who accepted bribes and anyone who accepted bribes and did not proceed to vote will not be immune from prosecution. Anyone who accepted the bribe and very loyally went in and acted according to the bribe giver's wishes, he will be immune from prosecution. So bribe takers are not immune, takers are immune, bribe givers are not immune. So this was such an absurd ruling, begun way back in 1998. It took the Supreme Court another 26 years to say this is a totally absurd judgment. And it's very recently in Sita Soren that they have said bribe acceptors are not in any way immune, because what they are doing is not an expression of a free will at all. It is out of favor. One of the oaths that you take as judges and members of parliament, that you will discharge your duties without fear or favor, affection or ill will. And it took the court 25 more years to see the logic of this, or the illogical reasoning of the earlier bench of the Supreme Court. The last context which I wish to refer to is the 10th schedule. This is the malaise of Ayaram and Gayaram. The same 1967 elections which saw the Congress lose power also saw large-scale defections from the Congress. Because people were desperate to form government, to topple the Congress government, they started offering pecuniary, advantages, offices of profit. Although the problem was noted even then, it took another 25 years for the amendment to be made to the Constitution, which would disqualify a member of parliament on two grounds. One is an individual member of parliament belonging to one political party switches allegiance to another political party. The mere fact of switching allegiance is enough to attract disqualification. Second, if that member of parliament acts contrary to the whip issued by his own political party and votes to that contrary unless there is a condemnation or it is done with the consent of that political party itself. These two grounds attract disqualification. What are the two exceptions? If a group of MPs who form part of the legislature party and are 1/3 of the total number of the MPs in that legislature party decide to switch allegiance, it will be called a split. The split will not attract disqualification. 2/3 of their strength decide to merge with another political party. This merger will not attract disqualification. So while an individual member switching allegiance will attract disqualification, a bunch of them constituting either 1/3 or 2/3 will not. There is an absurdity to this, of course. This was tested in the parliament. The 52nd Amendment was challenged. Again, the court was split between 3 and 2. The majority felt that issuing a whip to prevent a member of parliament from exercising his freedom of speech is a valid restriction, because they said a political party is formed by certain beliefs, and to maintain its integrity, it can control the freedom of speech of its constituents. Not a very convincing argument. Then it was argued before the Supreme Court, well, if one member switches allegiance, it is disqualification. If a bunch of them defect, how come it is not? They said, no, this means expression of an honest dissent. So basically, the majority was desperately finding grounds to uphold the amendment. As it turns out, the only thing they struck down unanimously was taking away the powers of the court to judicially review the powers of the speaker. As it turned out, since 1985, when the amendment was made, till about 2003, there were numerous instances of floor crossings, horse trading, switching of allegiances for pecuniary benefits and for and offices of profit. So Parliament in 2003 said, no more of this split exception. Merely because 1/3 of you split from the legislature party, you will not be immune from disqualification. But the merger exception continued. If 2/3 of you merge with another party, you will not be disqualified. The problem with this entire set of amendments was this: the person to decide on disqualification was the speaker. The minority opinion had rightly pointed out the speaker is, after all, a functionary of that very ruling party. How do you expect that speaker to be non-partisan? That speaker is bound to decide the way his party wants him to decide. And that has actually proven to be true in the years that followed. I'm going to pick up only 4 instances post-2014 where the courts have played a major role in regime change in different states. We first talk of Manipur. In 2018, there was an election, and it's a 60-member assembly. The BJP had only 21 seats, whereas the Congress had 28 seats. The BJP managed to cobble up some kind of a majority, a wafer-thin majority. One of the persons who walked across was a Congress MLA. He switched his allegiance to the BJP. Naturally, petitions were filed saying, disqualify this Congress MLA. The speaker, who belonged to the new ruling establishment, said, I will not take up this petition. Just sat on it. So they went to the High Court. Once, they went twice. In the second occasion, the High Court said, obviously there is a disqualification. This person who belonged to the Congress has walked across to the BJP. But strangely, the High Court said, no, but how do I issue a mandamus to the speaker to decide in a particular way? They had to go up to the Supreme Court. Almost 2 years later, in 2020, the Supreme Court says, this is clear, subversion of the 10th schedule. A speaker can't act so arbitrarily. If the speaker refuses to act, we are going to direct the High Court to itself decide the disqualification application. In fact, the Supreme Court went on to comment that if this is going to be the state of affairs, take away the power of deciding from the speaker. Give it to another neutral body, because we can't have a mockery made of the 10th schedule. This is so far as Manipur is concerned. Let's go to Karnataka, 2019. There's a coalition government of the JDS and the Congress. 17 MLAs, one fine day, decide they're going to resign. They resign. They are whisked away to a secret location. Nobody can contact them. The governor is approached and he orders a floor test. Now the Congress tells the governor, listen, can't have the floor test. We don't even know where our 16 of our MLAs are. They go to the Supreme Court, and what the Supreme Court does is remarkable. It says there will be a floor test, and there will be no compulsion for these 16 MLAs who are incommunicado to attend that floor test. This is by an interim order. Naturally, the government fell, and the new government comes into being. By-elections are declared, because these 17 have resigned. By-elections are declared. They all, who've actually been disqualified by the speaker, they all contest on a BJP ticket. They all win. And they all get cabinet berths. This was the first subversion in Karnataka in 2019. Now we shift to 2020 in Madhya Pradesh. In the 2018 elections in Madhya Pradesh, the Congress had secured 114 seats, the BJP had secured 109 seats. The tussle was between Kamal Nath and Jyotiraditya Scindia. Kamal Nath became chief minister. Scindia was nursing a grouse. Scindia waited till March 2020, just when COVID was about to begin. And I think it was 10th or 11th March 2020, he finally announced, I'm quitting the Congress, I'm joining the BJP. What he also didn't tell at press conferences, 22 of his loyalist MLAs were going to resign. They promptly resigned. They were whisked away in 3 chartered airplanes to Bangalore by the BJP. Again, floor test ordered for 26th March. The speaker said, I have to decide on the validity of these resignations. So I'm fixing the floor test for 26th March for me to decide. Shivraj Singh Chauhan of the BJP runs to the Supreme Court and says, oh, there's COVID, there is this, there is that. Please advance the floor test to 20th March. Everybody knows, with all these MLAs sitting in Bangalore, if you have a floor test on 20th March, the government is going to fall. The Supreme Court says, yes, we have to hold an early floor test. Let's advance the date to 20th March. So you're forcing the speaker's hand. What is essentially within the domain of the speaker to decide on the disqualification applications, to fix a date for the floor test, is all taken away by the speaker. The result is inevitable. The government falls and a regime change is effected. The last scenario is Maharashtra. Very interesting. So here in Maharashtra, you have the Maharashtra Vikas Aghadi. One of its constituents is the Shiv Sena. The Shiv Sena split down the middle in 2022. It had 55 MLAs. 40 MLAs headed by Eknath Shinde walked out. And they said, we are the real Shiv Sena. Uddhav Thackeray is not the real Shiv Sena. Now, Uddhav Thackeray's Shiv Sena had appointed Sunil Prabhu as the whip. So Prabhu issues a whip telling all the Shiv Sena legislators, come to Thackeray's residence on 21st June of 2022. The Eknath Shinde faction ignores it completely. So then, and they appoint their own whip. This is very interesting. They are part of the legislature party, but they appoint their own whip. So Sunil Prabhu then files applications for their disqualification. The Eknath Shinde faction is given time till 27 June by the Deputy Speaker to file replies to their disqualification application. On 25th June, Eknath Shinde runs to the Supreme Court. He says, I can't file a reply in 2 days. The Supreme Court obliges, says, yeah, you can file your replies by 12th July. What happens next is fascinating. Devendra Fadnavis tells the governor, now call for a floor test. You know, all these applications for disqualification are pending. He says, call for a floor test. I think those MLAs were all flown to Guwahati. They were in some 5-star hotel and some resort in Guwahati, cooling their heels. So now Sunil Prabhu runs to the Supreme Court and says, how can you have a floor test? All these disqualification applications have to be decided. The Supreme Court says, no, we'll have the floor test. We'll have the floor test. Disqualification applications can be decided whenever. Whatever happens in the floor test will be subject to the outcome of the petition. Uddhav Thackeray looks at it and says, this is the writing on the wall. Uddhav Thackeray, one day before the floor test, resigns. But the Shinde group is extra smart. They first appoint their own speaker. They say, we are the real Shiv Sena. The speaker appointed by them says, yes, Mr. Shinde, you are the real Shiv Sena. You are the head of that Shiv Sena. You are entitled to form government. He also says, yes, this whip appointed by you is the real whip. So you have a very obliging speaker. Now, 3 years down the line, the Supreme Court is hearing arguments and giving a wonderful judgment, accepting all of Uddhav Thackeray's arguments. It says, yes, governor had no business asking for the floor test to be conducted. Where was the material before the governor? Just one letter from Devendra Fadnavis. There was no material. Second, how could they appoint their own whip? A whip has to be appointed by a political party, not by the legislature party. And how could this speaker, whose appointment itself is under challenge, how could he have decided that he'll take up one set of disqualification petitions of the Thackeray group and not the other group? So on all points they agree. So Uddhav Thackeray is waiting for the last logical step that he should be reinstated as chief minister. Supreme Court says, sorry, we can't do that. Why? You resigned before the floor test. So we can't reinstate you. So you see the 10th schedule play out. It's a very interesting kind of a phenomenon where the court becomes a very important political actor. The court is deciding when a floor test will be held, how it will be held, and knows fully well, every one of these instances the court is told, this is an open, brazen instance of horse trading. These MLAs who've defected are all sitting in some resort. We as a political party cannot even contact them. This is a mockery of constitutional provisions. The court says, yes, all these problems are there, but that's for Parliament to sort it out. So it refuses to take notice of the brazen subversion of the 10th schedule and actually plays along, I would say, in bringing about regime changes which are all predetermined. So this is something that has to be very critically examined as to what the court is doing. So enough of all the stories now. Let's come to the last part. So I was beginning to ask myself, what do we make of all this? Let me summarize some of the main points I'm seeking to make. On the broad conspectus of separation of powers between the legislature and judiciary, the curtailment of the powers of the parliament to not permit it to alter the basic structure of the constitution can be termed as one of the most significant successes for the judiciary. It is commendable that this happened at a time when the executive of the day commanded a huge majority in parliament. The attempts by subsequent regimes enjoying a similar mandate to have this reversed or diluted have not met with success. But as a country, we need to remain ever vigilant to this possibility. It will depend to a large extent on the judiciary's ability to assert itself. There lies the hope for democracy. Every now and then, we do hear some politician being vocal about an unelected judiciary being able to overturn laws that have been passed by a sizable majority in the legislature at the instance, and this overturning happens at the instance of an individual or a group of them. But then that is the beauty of our constitution. It does not envisage a democracy which is merely majoritarian, but which accommodates difference, diversity, plurality, and is inclusive. The judiciary is the organ that enforces accountability of the legislature and, for the matter, of the executive, the accountability to the people. Second, in terms of interpreting the provisions of the Constitution, the design is to permit the judiciary to have the last word on what passes muster and what does not. The decisions we noticed where the judiciary decides what are the extent of Parliament's privileges and powers and the immunities of individual legislators cannot be seen as aberrations, but necessary for an orderly functioning of our institutions of democracy. Understandably, the judiciary has also rebuffed so far the attempts by the legislature to whittle down its powers or its independence. One cannot say with the same degree of confidence that the judiciary has been able to stand up to a powerful executive. It appears that the last time that really happened was more than 5 decades ago in 1973. Even from the point of view of federalism, in terms of distribution of finances, the power to levy taxes We need the court to strike a balance between what the center can legitimately collect as taxes without encroaching the domain of the states that have been clearly delineated in the Constitution. Therefore, the tussle between the two legislative bodies, the Parliament on the one hand and the state legislatures on the other, in the matter of taxation, requires a neutral umpire like the judiciary. In the recent past, another threat to federalism is the actions of the governors of various opposition-ruled states in not assenting to bills passed by state legislatures. The tussle then is between the union executive and a state legislature, and thereby the state executive. This too has needed judicial intervention. We need, therefore, the judiciary to be strong, consistent, independent, and free from pressures of all kinds. But has that been possible? In the cases that we have reviewed, there is one trend that is discernible and which is a cause for some concern. Where it is a coalition government at the center, the judiciary is far more assertive than it might be when it is dominated by a single political dispensation. In the past decade, the judiciary has been less willing to strike down enacted laws, particularly when they concern national security, sovereignty, and integrity. It has been readily willing to enforce draconian criminal law provisions that severely curtail individual liberty. Also, it has delayed the taking up for consideration the challenges to some of these laws till a point when the outcome is a foregone conclusion. I can think of numerous examples. Article 370's abrogation, for instance. Even the electoral bonds. When they finally found it to be illegal, they added a rider saying that the monies collected do not have to be returned. So basically, the result was a fait accompli. Likewise with demonetization. All these challenges are taken up not immediately, but several years down the line, making the whole exercise futile. Add to this the decisions rendered under the 10th schedule, where it has been a major player in bringing about regime changes, subverting the spirit of the anti-defection law. It has willy-nilly either taken over the functions of the Speaker by preempting the decisions on the disqualification petitions, or has condoned the delayed consideration or even the non-consideration of those petitions by a Speaker. It cannot be a mere coincidence that these decisions have invariably favored one political dispensation at the center. There may be some justification in the view expressed by some legal scholars that the judiciary has in the recent past fallen short of the expectation of being a counter-majoritarian institution. We have talked about the legislature and the judiciary. One question that needs to be asked is, how democratic are these institutions in themselves? Before we do that, it might be interesting to see how the holders of power in these institutions perceive themselves. And this is some fun I'm going to have. It must be recalled that the colonizers had the royalty before them as role models when it came to the grandeur and pomp that accompanied the seats of power. The awe-striking architecture of the buildings, the high ceilings, the ornate furniture, and the conscious distance between the deliberately heightened daises where those in authority sit and those whose remonstrations they expect to address can sit. The Rashtrapati Bhavan could easily compare with any of the erstwhile palaces, and so is the modern parliament building and even the architecture of some of the modern high court buildings. I don't know how many of you have been to the high court in Lucknow. You will understand what I'm saying. The nomenclatures of the governor's residence may have changed from Raj Bhavan to Lok Bhavan, but they remain palatial mansions behind high walls beyond easy access to the common person. The forms of address, His Highness, His Excellency, My Lord, the liveried ushers, the bedecked bodyguards, the stiffening and withdrawal of human bodies as the persons of eminence walk past are all vestiges of modern royalty. And when they travel, not only these eminences, but even the so-called people's representatives travel in a convoy of cars, many of them of foreign origin, hogging all the road space and creating huge traffic snarls. The judiciary too has been unable to shake off its colonial forms of address, dress, and protocols. There are issues with the feudal and patriarchal practices within the institution. Whether it is the legislature or the judiciary, it is difficult to confidently state, even after 75 years, that they are truly representative of a cross-section of Indian society. They continue to be dominated by men, the upper castes, and revel still in feudalism and patriarchy. Women's presence, whether in positions of power and authority, within political parties, or in the legislature as a whole, is nowhere near proportionate to their actual numbers in the population. The 33% reservation promise is yet to be fulfilled. Intra-party democracy is a chimera. It is the age of the high command. But it is not just the forms of the internal arrangement that has not changed. The mindset of those occupying important positions and their sense of responsibility and accountability to the people is far from being decolonized. It is yet to be fully aligned with the constitutional values and expectations. What economists would term as rent-seeking permeates the mode of functioning of many a government servant or public servant, whatever little power or influence they may wield. A far cry from Dr. Ambedkar's hope that decision makers in administrative positions and elsewhere would embrace constitutional morality as a creed and imbibe constitutional values in their everyday functioning. Did we say a system of the people, for the people, and by the people? That needs a radical shift, a different way of thinking, a rebooting, and a rediscovery of character as a nation. It matters, therefore, also that constitutional values are imbibed not just by each of our judges, but by each legislator and each bureaucrat and each minister. In their actual functioning, if one views the proceedings within its precincts, easily accessible now through live streaming, what we see in the legislatures is a spectacle best avoided. This is not to say that there are not some spirited legislators that make meaningful interventions, giving analytically incisive accounts of some of the bills tabled. But this is all too far and few in between. Progressively, the frequency and length of the legislative sessions have shortened. Ministers can get away with making misleading statements during the question hour. Just to lighten up our discourse a bit, I got curious and went back to Yes Minister. Every time I'm stressed out, I go and watch Yes Minister or Yes Prime Minister. So this is the dialogue between Hacker, the minister, and the only and great Sir Humphrey, his secretary. So Hacker says, so when this next comes up at question time, you want me to tell Parliament that it's their fault that the civil service is too big? Humphrey says, but it is the truth, Minister. Hacker says, I don't want the truth. I want something I can tell in Parliament. The scenes on the floor of the House are invariably chaotic, with questions not being allowed to be raised, motions not being allowed to be tabled, walkouts, boycotts, mass expulsion, suspensions of members of the opposition parties, and during that period of expulsion, suspensions, rushing through bills of great importance, and of course, wholesale expunging of remarks. Now in the live streaming, he can even cut off the feed. The speaker says, none of this will go on the record of the House. Decorum is felt by its total absence. I was looking at humor in our parliament, and apparently this happened in the Indian parliament of yore. Lohia, whose antinomy to Nehru was well known, Lohia told the House that Nehru wasn't an aristocrat that as he was portrayed. I can prove that the Prime Minister's grandfather was a chaprasi in the Mughal court, Lohia said. To which Nehru smiled and replied, I am glad the Honorable Member has at last accepted what I have been trying to tell him for so many years, that I am a man of the people. The expectation of opponents dealing with each other with civility and respect appears to be unrealistic. Once, while rejecting an amendment moved by Rajaji, Nehru said, you see, Rajaji, the majority is with me. Rajaji countered, yes, Jawaharlal, the majority is with you, but the logic is with me. Nehru laughed with the House and Rajaji's amendment was carried. We are missing those scenes today in Parliament. The Speaker's position in the Lok Sabha and the Vice President's chair of the Rajya Sabha was seen as integral to the working of a responsible government, standing at the junction of the executive-legislative relationship and the daily operation of parliamentary democracy. I'm thankful to Professor Sarat Bose for sharing with me an Abu Abraham cartoon, where the fulcrum on which the whole balance of the judiciary and the legislature is, it reads democracy. Thanks to the live streaming of proceedings, the partisan behavior of these office holders and their utterances, both within the precincts of the House and in public fora, do not inspire confidence in their ability to be statespersons capable of rising above their party affiliations. We also saw how the 10th schedule has resulted in the power being shifted away from the individual legislator to the leadership of political parties. Madhav Khosla notes how today the only importance given to a legislator of a ruling party is at the time of elections. Once the member is part of the ruling establishment and in the parliament or in the legislative assembly, he has no role to play. They find they're not able to speak freely. So all their energies are diverted from the legislative arena to the electoral arena. They're more bothered about spending the funds allocated at their dispensation, opening bridges and culverts with their names on it, because they know at the time of elections, again, they have to go and campaign and get votes. So some of them actually do grandstanding in parliament. You will find ruling party members themselves behaving very unruly. And you wonder why? Because they want to attract attention. Otherwise, nobody's going to notice you. You're just part of the ruling establishment. So the legislature itself has become redundant as far as the ruling party is concerned. It is unable to be a check on the executive. We have also to try and understand why there are friction points between the courts and the legislators. Judges do have adjustment issues when it comes to both caste and class, and a sense of superiority in terms of learning and experience vis-a-vis legislators who are people's representatives. You know, protocol matters a lot to judges. I've been part of that community for over 17 and a half years. A colleague of mine, to walk in the corridor from one end of his chamber to my friend's chamber in the other end of the corridor, he will walk in a procession. His PSO will walk in the front and his usher will walk behind him. They are so caught up on protocol. Many of them were very upset when the red light could not be put on their cars. They tried to find other ways, so they would order a police escort. And on the police jeep, you can have the blue and red light. So they're so caught up and trapped by all of this that they're unable to emerge from outside this. And it's about an issue of show of power, of status, of jockeying for a position. In the rarefied atmosphere in which they function, I'm talking of the judges, and in the circles in which they socialize, they are naturally removed from the rough and tumble of daily life. It should not be surprising that some of them give us a distinct impression of being out of touch with ground realities. In this scenario, and I must tell you this funny episode, told to me by one of the judges themselves, they're so used, and my partner Usha calls this acquired helplessness. We can't carry our own papers, we can't open our own doors, everything has to be done for us by somebody else. And my friend Justice Chandru says we are all like Jesus Christ before we enter the court. We put our hands up like this, and the gown then slips on our shoulders by our usher. So she was saying how she had gone on a visit to New Zealand, and her sister-in-law drove her around, and the car came back to the house, and my friend was still sitting in the rear seat till my sister had to come around and say, Didi, this is not the High Court of Delhi, you have to open your own door. In this scenario, it is difficult to imagine judges considering legislators as co-equals who occupy positions in another constitutional organ of co-equal weight. When speakers are therefore entrusted with adjudicatory functions, judges are easily inclined to act as their appellate authorities. All this could possibly explain why the legislature today commands little respect, either among the general populace or among judges. Even judges too realize that their standing is not what it used to be, say 4 or 5 decades ago. This is not to say, and I want to emphasize this is not to say that all legislators and all judges are of the same ilk. There are fine exemplars among them too, and hopefully they will be the role models for those that follow. In fact, I personally am of the view that there is many a politician and many a judge, as there have been in the past, who take their tasks seriously, adhere to constitutional values, and try to give off their best. They are to be admired that in the midst of the general morass of an amoral political class and a general regression in societal values, they have the courage and the conviction to hold their own. They need to be identified and encouraged so that they may inspire the next generation of aspirants. In the end, we must live in the hope of a better tomorrow. It might be useful to sign off by recalling the words from the advisory opinion of the Supreme Court way back in 1964, and I quote, "It is necessary to remember that the status, dignity, and importance of the two institutions, the legislature and the judicature, are derived primarily from the status, dignity, and importance of the respective causes they are assigned to, their charge by their constitution. These two bodies, as well as the executive, which is another important constituent of a democratic state, must function not in antimony nor in a spirit of hostility, but rationally, harmoniously, and in a spirit of understanding within their respective spheres. For such harmonious working of the three constituents of the democratic state alone will help the peaceful development, growth, and stabilization of the democratic way of life in this country. Thank you very much for this patient hearing.
Thank you very much, Justice Muralidhar, for delivering such a befitting Sarat Bose lecture. There was analysis, of course, of the balance between the three branches of government, but you have also shown yourself to be a great storyteller. Finally, of course, you closed with some normative comments. Our democracy does desperately need a reboot, and we need to somehow restore the fine balance between the legislature, the judiciary, and the executive. We have such a distinguished audience that we will take a couple of questions, and let me begin by posing one. You mentioned that there are moments when we enter into an era of electoral autocracy in the name of democracy. And at those moments, the judiciary often seems to bend to the will of the executive. The question that I have is that you had a wonderful survey of history, and what struck me was the point that you made, that it was at the height of Indira Gandhi's power and popularity, 1973, that, in fact, the Keshav Nath Bharati case resulted in an assertion of the basic structure of the Constitution. But then I want to take you ahead by a couple of years into the period of the emergency. And at that time, the judiciary not only held the imposition of the emergency to be perfectly constitutional, but in fact, it ruled by a 4-1 verdict with Justice H.R. Khanna dissenting, that even the suspension of habeas corpus was constitutional and lawful. Now, I'm posing this in the context of history, but my worry is really much more about the present, because I do believe we are living through an era of electoral autocracy, and the 4 examples that you gave of the judiciary's role in regime change at the state level seems to suggest that the judiciary today is basically siding with the party in power at the center. And you also made passing mention of Article 370, indeed the whole Jammu and Kashmir Reorganization Act, in which case, after a 5-year delay, the judiciary more or less said that what the executive had done was perfectly constitutional. Now, when something like the 4-1 verdict happens on the suspension of habeas corpus, the question that I would like to pose to you is that should we be thinking in terms of the individual judges? Because you did point out that individuals are important within these institutions. Should we consider the 4 judges who ruled that the habeas corpus was, suspension of habeas corpus was constitutional? Did they have a personal flaw? Did they just succumb to the will of the executive? Or were they relying on a very literalist reading of the Constitution, and therefore they could have grounds, they could have a justification for the kind of opinion that they gave. Now, if the latter is the case, then the legislature, particularly the parliament, as a living institution which can amend the constitution, enact new laws, would have a big role to play. That, not allow those literalist readings of certain clauses of the constitution. For example, we have the emergency provisions in the constitution, which there were some members of the Constituent Assembly argued that they shouldn't be there. So unless and until we then have a parliament which makes both our constitution through judicial amendments and through the enactment of new laws, making our polity more democratic, more federal, we will continue to have judges who will provide us with literalist readings and buttress, authoritarianism. Electoral autocracy is the context in which those kinds of decisions are being made. So my question was really about the responsibility of individual judges versus what is there in the Constitution and laws, and whether they need to be amended and changed in a more progressive direction. Today's government wants to take it in a more regressive direction, but should we take a status quoist position, or should we take up the challenge and argue for a more democratic, a more federal, a genuinely secular India?
Let's take one or two other questions, and then Justice Muralidhar will respond to them as a bunch. Yes, here. Mm-hmm. And then here. I've seen.
Hello. Thank you, Justice Muralidhar, for your enlightening discourse. My question to you is, as long as the lure of post-retirement appointments for judges exists as the chairpersons of tribunals, commissions, and a whole host of other constitutional bodies as well as legal bodies with a plethora of perks and privileges, is it even possible for judges to let go of that, like El Dorado, and not be amenable to the wishes of the disposition in power?
That did occur to me. Of the 5 judges, right, in the Ram Mandir judgment, November 2019, one became the Chief Justice, which he was supposed to become right away. Another became, the then Chief Justice became a Rajya Sabha MP within a few months. And the third was also appointed governor of a southern state, Andhra Pradesh. Right, yeah, exactly. Yes.
Thank you, Professor. Thank you, Justice Muralidhar. It's a very enlightening presentation. I just want to actually add to Professor Bose's initial position on the electoral autocracy, which actually was largely a part of your lecture. Do you think that, because electoral autocracy and populism and majoritarianism is not in our hands, so it's absolutely in the electoral arena that gets decided. So do you think that proportional representation can be an antidote, can be, if we can actually replace the first past the post system with proportional representation? Or maybe what Ambedkar once thought about the multiple member constituency, if that could be one way to get out of the electoral autocracy, the problem that we are in. And the very quickly second is that on the governor's position in West Bengal too, we have a governor who is not directly a political party member, comes from the bureaucracy, but then sits on the bills, and so you have immunity of the governor in the constitution. But can we think about a kind of bill which will restrict the governor, but to not misuse the discretionary power and say that, okay, you can only have the bill for 3 months or 6 months, and you can't sit on the bill for years?
Good evening, sir. This is Anak Ganguly from Anandabajar Putrika. Yes. My question to Justice Muralidhar is, how does he, as a jurist, look at a scenario when an elected chief minister of a state is accused of snatching away documents during the raid of the central agency on a private premises?
I have a very brief question. Most of it has been already addressed. So I just wanted to say that you did mention, you did talk about the fact that how legislation is being conducted these days, implemented these days in Parliament without much vetting, which has become a norm. It is, bills are passed in the din, bills are passed without sending them to any of the committees to be vetted. And therefore, does the judiciary therefore have to look at a new, progressive, more active role at the legislation, at those legislations when they are coming to court for some sort of an reprieve? Because they have not been vetted by the number of parliamentarians who have been elected to the House.
Hello, Doctor. Thank you so much for your brilliant speech. It is my inadvertence that I did not carry a dictionary. Otherwise, I would have better understood your speech. Sorry for that. But in your entire speech, you obliterated to mention about the office of the Attorney General of India and the Advocate Generals of the states. Now, from what I understand, this is a constitutional liaison between the legislature as well as the judiciary. I would like to hear a critical comment from you as to whether it is the right time to promote these offices as being the liaison, as being the liaising factor between these two branches or not. Yeah, that's my question.
Good evening, Justice Muralidhar. My question is very simple. So in the recent past, we have seen that there have been a lot of collegium recommendations in respect of elevating judges, but we have seen that the central government has withheld those recommendations and have not elevated them. So my question to you is how are we seeing that in the future of Indian judiciary and its independence?
Okay. Yes, please.
Good evening, sir. My question was, as you talked a lot about the tussle between legislative and the legislature and the executive, the judiciary. My question was, what could be the way forward in as much as the legislature, in a lot of circumstances, refrain from acting, and the judiciary has the hands are tied, as you said. Or as I deciphered. So, what could be done in such circumstances like defection or criminalization of politics? That would be my question. And the judiciary as such might not be able to do much about it as the judgments show. So,
yeah, I understand.
Okay,
yes, please.
Let's give everyone a chance who really wants to ask a question.
Please. Yes.
হ্যাঁ, ভদ্রমহিলা আছেন এই মাঝখানের দিকে। হ্যাঁ, ওনাকে।
Thank you, sir. As someone in the field of education, I have a question that is, I'm very curious about it, and I'm also slightly uneasy about asking it. And I realize that that is how the state of things has become. My question is, what formal basis do initiatives like Pariksha Pe Charcha have that as a teacher, we are required to register, formally register names and necessary details of students? They are citizens, of course. So the fact that we compulsorily have to register them. So that is what I'm curious about.
Understood. Now over to Justice Muralidhar for his responses.
All right. So let me start with the easiest first on collegium recommendations and what is the central government doing to those recommendations. You know, Professor Bakshi was asked very recently, I don't know if you saw the clip. He was sitting with Justice Oak and Justice Gautam Patel. They had a discussion. And Professor Bakshi was asked from the audience, what are the 3 things he would like to see in judges of the Supreme Court and the High Courts? He said the 3 things are spine, spine, and spine. So what we are finding, and this is astonishing, that the Supreme Court is not willing to respect its own judgments. Once the Supreme Court reiterates and sends a name, there is no option for the central government but to appoint the person. So it goes far beyond what you're even suggesting. I, from Orissa, sent a set of recommendations, 1, 2, 3, 4, and 5. The Collegium Supreme Court accepted those recommendations, sent them to the central government. The central government issued warrants for 2, 3, 4, and 5. I had to swear them in because warrants were issued. When I asked, what about serial number 1? The Supreme Court in turn said, oh, we don't know why serial number 1 has not been notified. It asked the central government, why have you not notified? No answer. After 2 months, serial number 1 was notified. What it effectively did was alter the seniority. So these were not results that one anticipated at all. So I'm just saying the executive control over the whole process today is very pervasive, far more pervasive than we imagine. They have informal vetting mechanisms. And this is openly accepted by them. Even if the IB clears your name, they may still have a supranational, extra-constitutional mechanism which can vet the names and decide, oh, this we can appoint, this we cannot. It is only for the Supreme Court to get to the bottom of this. And with the Supreme Court is disinclined to act, just imagine one judge is transferred to a high court, recommended to be transferred. The central government says, no, this judge will go as member of the collegium of that high court. We don't want him to go as collegium of that high court. So the Supreme Court, in fact, this is the most open acknowledgement, I would say, so far. The Supreme Court in its resolution says, as requested by the central government, we are now transferring this judge to another high court, where it will be far in the bottom of the pecking order. So I'm just saying we have come to a very sorry state of affairs where the Supreme Court collegium is not asserting itself. This has happened for some years now, but it is not changing at all with every successive Chief Justices, and this is a cause for real worry. We'll have to hope that Supreme Court will regain the courage to assert itself and to say a judgment declared by the Supreme Court is binding on everyone. We will not allow that judgment to get diluted like this. That has to come only from them. The Attorney General and Advocate General, you could see the sharp dip in the standards from the times of, Setalvad and Daftari in the initial years. Today, the Attorney General and the Advocate Generals are acting as lawyers for the executive government. They're not acting as officers of the court. As a lawyer, you would have heard this expression, officers of the court. Sometimes the executive government may take an unreasonable stance. But you, as a law officer, are supposed to be objective before the court, which is why you have got that elevated status in the Constitution. Even if the executive government is of a certain point of view, in the legislature, you can give your honest view. They expect you to do that because of your standing, your experience, the respect that you command for your learning. This is why you're supposed to be chosen as Advocate General and Attorney General. You're not supposed to be merely acting as an advocate for the government. Then you're not any different from a government pleader or a public prosecutor. We expect objectivity. Mr. Mitra is here. We expect objectivity even from those government lawyers and public prosecutors. When they stand up to oppose bail, if you know that the person has served more than half the sentence, which he would ultimately be awarded even if he is found guilty, an officer of the court would tell the judges, no, this is not a case where bail should be refused. You don't have that fairness in the court today. So this is really a problem that these positions are not seen any different from any other advocate for the government. That needs course correction, for which you need the bar to be very active. Today you have capture of the bar councils by political forces. And the Bar Council of India is completely aligned with the ruling dispensation. The chairperson of the Bar Council is given a seat in the Rajya Sabha. We are taking exception to Gogoi being offered Rajya Sabha seat. We should equally take exception to a Bar Council chairman being offered a Rajya Sabha seat. Then he should resign as Bar Council chairman. See, if we don't have independent lawyers, you're not going to get independent judges. Judges don't suddenly become independent overnight. Judges are also political entities. They also have political affiliations. They try to keep that all behind when they sit on that seat. But sometimes it succeeds, sometimes it doesn't. People ask me, do judges get pressured by an executive government? Somebody calls you on the phone, says that you have to decide it this way or that. My answer is very simple. If I, as a judge, already have my politics aligned with the current political establishment, nobody needs to tell me anything. I know what to do. When Rupert Murdoch took over newspapers, there are some people from the media here, none of the journalists of that newspaper had to be told what kind of stories to write and what not to. They knew. If Murdoch has taken over this paper, some of the stories we write will not pass the editorial desk. They'll stop writing it. Likewise, some of the chief justices today in the various high courts, some of the judges sitting in the collegium, know that certain names will not get approved by the government. They will simply not send those names. Likewise, the difference between Keshavananda Bharati and ADM Jabalpur was this. I told you about packing the judiciary. Every one of those judges who were deliberately picked up in the expectation that Golaknath will be overruled, in fact constituted those 6 judges in the minority in Keshavananda Bharati. The calculation was right. Now 3 of the judges resigned, who constituted the majority in Keshavananda Bharati, because of the supersession. It became easy now to constitute a bench where most of them were aligned with the ruling establishment. So the politics of judges is something that we have to account for. I've been saying this in several fora. We don't have a critical legal studies movement in the country. We need to know what is the political inclination of a judge. Where does the judge come from? Let me say that I've been a prosecutor in all my life in the bar. I'm a good criminal lawyer, but a large portion of it I've been a prosecutor. I now get appointed as a judge of a high court. It will take me at least 2-3 years for me to get out of this mindset of being a prosecutor. If I'm straight away put on the criminal roster on coming onto the bench, everyone in the criminal bar knows me already. They know which kinds of matters I will oppose tooth and nail. You cannot expect the judge to be, suddenly, overnight become a fair, impartial judge. No. So such judges will be kept away from the criminal roster for a while. There are so many rosters for the judges to deal with. So the proclivities of judges are known, which is why in this book, sir, in my introduction, I talk about the master of the roster. That's a very, very important power. As a Chief Justice of India today, I know which judge is likely to decide which case in which way. If I'm marking a bail application of a certain person to a certain bench, I know to a large extent what is going to be the result of that bail application. I can say this with confidence because I myself have been the Chief Justice of a High Court. I cannot claim that I don't know how my judges are going to decide, or I can't be so naive to think, all my judges decide the same way. All these applications, they're all neutral, they're all fair, they're all objective. No, they're all human beings first. So we need to know our judges, for which the critical legal studies movement is very important. Where do we pick up our judges from? Third, we need to give them orientation on constitutional values. We are not giving them that kind of orientation. There is no human rights orientation. There is no orientation on constitutional values. And not just for judges, for lawyers. We have a law officer who says in a public fora that anyone who walks into the court claiming enforcement of fundamental rights should first demonstrate that he has fulfilled fundamental duties. Where does this law officer get this from? Which provision of the Constitution? It's his understanding of the Constitution. Now, sir, the troubling part is this. We as a people have adopted a system where these electoral autocracies come into place. So we have to work in generating public opinion amongst we as the people for that regime change. And there's no guarantee that the new regime will think differently on issues of human rights or personal liberties. It's only an expectation that we have. So ultimately, it all comes to each one of us. Whichever new system we may put in place, if the persons in those systems are not going to function in a manner that aligns with our constitutional values, then the results are not going to be different. Let's say corruption as an issue. You vote out a certain ruling dispensation in the expectation that the next ruling dispensation will not have so many scams and scandals. And our expectation has been belied time and again because there seems to be some erosion of the moral character of us as a country which we need to regain. How we do it is for us to determine, at least we do not encourage amoral behavior. We need to be very careful of whom we vote for. Post-retirement jobs are a real problem, are a serious problem. We have provision in the Constitution which says there's a cooling off period for a comptroller and auditor general. There should be no difficulty in imposing a cooling off period for all holders of constitutional posts. But it might still solve only some part of the problem, sir. Because there are numerous other ways in which your interests can be accommodated. You can be appointed arbitrator by the government of India in international arbitrations. All right. That's not some post. That could be far more lucrative than any of these other offices that you spoke about. So ultimately, it's actually the character of persons. If they're seeking these kind of rewards, we cannot stop them by these provisions. It will require a moral character, an assertion of that moral character. About this Pariksha Pe Charcha, it's a real problem. So there's a wonderful interview with Christopher Jaffrelot. He's asked, do you think this is fascist? He says there's a difference between fascism and authoritarianism and totalitarianism. So he says that this is totalitarianism. Totalitarianism is the Stalinist model. No dissent will be tolerated. And brainwashing is taken as to a kind of a device. Everybody has to sit and everybody has to listen. Everybody has to mark attendance. So this is the kind of state we are in. And to make teachers, educators do this day in and day out is painful. So we need to remember all of this next time we go into the election booth. And your experience hopefully will be shared amongst others. And the choices we make are going to determine the future of this country. You have to be free from these totalitarian devices of control. Parliamentary dysfunctionality, of course, this is a serious problem, but to expect the judiciary to find answers is asking for too much. I have often felt that when you have constitution benches set up, again it comes to the master of the roster. On a lighter note, the Mirzapur Buffalo Traders Association was challenging the complete ban on cow slaughter, on cattle slaughter of all kinds in Gujarat. Now, one judgment of the Supreme Court of 1955 was coming in the way of this cow slaughter ban being upheld. So the court constituted a bench of 7 judges to overrule the judgment of 5 judges. The 7-judge bench was comprised of 6 vegetarians and 1 meat eater. And that meat eater dissented. So the power of the Chief Justice to constitute benches is something that we have to seriously interrogate. Every inch of power that we have needs a check. And the document which helps us to do it is the Constitution. The organ that can help us do that is the judiciary. So if we do not have strong and independent judges, we cannot achieve these results. For strong and independent judges, we need strong and independent lawyers. Without a strong and independent bar, you cannot have independent judges. For having strong and independent lawyers, we need to be having law students who embrace constitutional values. So it's not just a cliched thing that I'm talking about. We really have to start from each one of us here and now. Only then that change is possible. But I'm hopeful that change will happen because we look back at history, no authoritarian totalitarian regime continued forever. There were changes, there were revolutions, there were protests. Some of them successful, some of them not. They did bring about some change. And we should hope for that better tomorrow. And let's hope that hum dekhenge.
I think that Sarat Chandra Bose would be very happy that we had this amazing lecture and the animated discussion to follow. I think it's exactly this kind of discussion that is needed in the public sphere in our country today, free and unfettered and fearless. And we at Netaji Bhavan are proud to provide such a forum and a venue and a platform for this kind of event. Of course, 23rd January is coming up in a couple of weeks. But before that, next week is the 85th anniversary, 85 years since the Great Escape, the Maha Nishkraman. And on the eve of that history-making and history-changing event, we have a Shishir Kumar Bose lecture on something that is of interest to historians, philosophers, political scientists, and others, but also to the predicament of our country today. We have a speaker, Anshul Chaturvedi, who's actually works as an editor at the Times of India, but is a great student of the lives of both Swami Vivekananda and Netaji Subhash Chandra Bose. And next Thursday, the coming Thursday, at 6 p.m. in the evening, on 15th January, the day before the Great Escape, Mr. Chaturvedi will deliver the Shishir Bose lecture in this Netaji Pavilion on the idea of faith and the idea of India, interconnections of Vivekananda and Subhash, the idea of faith and the idea of India, interconnections of Vivekananda and Subhash. So I hope many of you will join us for that lecture. The invitations will reach you very shortly. We have a last ritual. We always present our esteemed guest speakers at Netaji Bhavan with a selection of books that we believe they will find interesting. And may I ask Professor Sugata Bose to hand over the books we have chosen for Justice Muralidhar as a token of our regard for him and our gratitude for coming here today. And as a personal gift from me, I am also adding my most recent book, Kashmir at the Crossroads. This is the 2024 paperback edition, the most up-to-date version. Thank you very much. Good evening. I believe we have arrangements for a steaming cup, or rather bhar, matir bhar, of coffee waiting for you outside before we all adjourn for the evening and go away. So please do have a steaming cup of hot coffee on this unusually chilly evening before you depart. Thank you for coming and see you again soon. Jai Hind.